Queen Bee's attorney filed a motion with the court on 7/25/24, and today we're going to read that motion. Not only did he file this motion with the court, but he included some really spicy emails at the end, so make sure you stick around for that because that's the best part. Objection to request for telephonic virtual hearings. Queen Bee, through counsel at attorney, objects to conducting the upcoming hearings set for August 16th, 2024 as follows. Introduction. BHB unilaterally noticed up several motions for remote hearings without comporting with the local rules concerning remote hearings. This objection is asserted under that local rule. In short, this long-in-the-tooth case has not even passed the pleading stage. BHB is not calling notices for hearings, and her behavior has been erratic and problematic to say the least. Without in-person hearings to temper her worst behaviors, the waste of this court's and defendants' resources will continue. BHB temperament in person was much more moderated, and her problematic behavior cooled after her one and only in-person appearance in this case. Indeed, even her online reporting of her own case was more tempered after that in-person hearing. In-person hearings are appropriate here. Governing law. The Ninth Circuit Administrative Order number 2023-03 governs BHB request. It amends the Ninth Judicial Circuit Court rules, local rules. Local Rule 1.80 was amended to provide the court with discretion to allow remote hearings to address, among other things, cost or time saving. Local Rule Part 1.80. Nothing in the rule mandates remote proceedings, and the court may require in-person hearings if the judge determines the nature of the hearing, the conduct of the parties or attorneys in this case, or the need to allow parties and their attorneys to communicate and negotiate effectively requires it. Argument. First, in-person hearings are necessary to bring some semblance of proper order and civility to this action. BHB has in the past refused to speak with undersigned counsel, Exhibit 1. She later said that she will only if Queen Bee caved to BHB's demands, which would require Queen Bee to stipulate to a violation of the local rule, Exhibit 2. Since then, BHB has uncivilly lashed out in emails to undersigned and repeatedly threatened to make him a party or to seek disciplinary action against him, Exhibit 3. It has now extended to her public filings. For example, in her response to motion to dismiss second amended complaint filed July 22nd, 2024, page 8 through 10, she states, death and attorney response is disgusting and sanctionable. Attorney's conduct may rise to inclusion into this lawsuit, no different that Stephen Bertolino in the Gabby Petito case, which Bertolino settled with the family. Illinois law prevents BHB from reaching out to his client directly. All communication must go through attorney. His response is sanctionable, among other remedies at BHB's disposal. Attorney conduct has been atrocious and bodes more in assisting Queen Bee in facilitating and shielding Queen Bee conduct so Queen Bee can continue Queen Bee's terror upon BHB as opposed to Queen Bee's counsel. The court only need go to Exhibit A of that motion to see that undersigned was completely reasonable in explaining the bounds of his representation, and BHB response was anything but. Undersigned is just doing his job and not getting dragged into whatever personal animosity may exist between the parties. Meanwhile, BHB is sending series of single sentence emails lashing out over the course of just a few minutes. It seems that the gravity of an conduct appropriate for judicial proceedings needs to be impressed upon BHB, which can be accomplished through her presence in the physical halls of justice. Undersigned has not seen the likes of such behavior from any opponent, even those who have been disbarred and pro se litigants. The court should exercise its discretion to facilitate the communication and any potential negotiation between undersigned and BHB. See Local Rule Part 1.80. Second, BHB has not made judicious use of remote hearings. She routinely leaves motions hanging without noticing them up for months at a time. She still has not noticed up her motion for protective order, nor has she noticed up her motion to dismiss the present iteration of counterclaims, nor has she answered them. Without a physical presence where good order and the need for docket management can be impressed upon her, BHB will continue dragging this case out. Third, this is a business dispute by BHB. She chose to file suit here for her business, which involves extensive travel. Since the case has begun, BHB has traveled to numerous states for her business. There is no reason she cannot travel to Knox County, Illinois. Conclusion. All contested hearings in this this matter should be held in person. However, per the local rule, this objection is lodged only as to the August 16th, 2024 hearing noticed up by BHB. Respectfully submitted, Queen Bee, by Queen Bee's attorney. Notice of filing and certificate of service. Undersigned certifies and states this document was filed on July 25th, 2024, using the Court's Odyssey e-filing system. He further certifies and states it was served by electronic mail to the persons below on the same day. To Bullhorn Betty, aka BHB, sent by Queen Bee's attorney. Okay, ladies and gentlemen, I hope you're ready because here we go. We are on to the exhibits, and in the exhibits are the emails. So let's get started.
Bullhorn Betty. To QB's attorney. Date, Thursday, July 20th, 2023, 10:50 and 45 seconds a.m. Mr. Attorney, your professionalism is disgusting. My concern would not be a lawsuit filed against you, but rather a complaint. I am almost certain you compare my channel and what I've said to your client. My case is in good standing. I understand the elements, I've expressed the elements in my complaint, and provided the evidence to support those proper and legitimate claims. If you were going to write me to continue to harass me on her behalf, you've got a big problem, and I'd be more concerned about other more formal repercussions than I would be a lawsuit from me. I'm unsure what your client has told you about me, but I will not allow you to continue her harassment upon me through emails because you're her attorney. Furthermore, if this level of harassment continues from your office, I will be filing your demand letter in the court for the judge to take judicial notice of. Now, if you would like to speak to me and address me with some professionalism, I am happy to work with you on this matter as I am opposing counsel by way of me representing myself. Again, I have stated legitimate claims and I have met the elements of those claims. And since it appears that you do not wish to work with me, I'm going to demand that you discontinue communication with me until we are before the judge to discuss this very matter. Respectfully yours, Bullhorn Betty.
On Thursday, July 20th, 2023 at 11:23 a.m. QB's attorney, MX, BHB. I received your email. While I disagree with your conclusions, we note your intention to persist and will proceed accordingly. As for my letter, and to prevent a misunderstanding causing you to file another suit, please note that under Illinois law, defamation requires publication to a third party. Even if the letter's contents were untrue, and were not subject to the litigation privilege, then it still was sent only to you. Thus, there is no basis for a claim.
From Bullhorn Betty. Sent, Tuesday, July 18th, 2023, 4:23 p.m. To QB's attorney. Dear Mr. Attorney. First, I found your demand letter very insulting and lacking great facts. Second, I find it hard to believe an attorney would initially try and intimidate me through a demand letter. Your information is very much incorrect. There have been 2 lawsuits, both of which I prevailed on. I don't take the act of suing someone lightly. I have repeatedly told her to stop. She continues to lie about me. Even your demand letter is defaming and untrue. Have her give you all those lawsuits I've filed. No, I will not drop the lawsuit. Have a great day. Respectfully yours, BHB.
From QB's attorney. Sent, Tuesday, August 15th, 2023, 10:55 a.m. To Bullhorn Betty, MX, BHB. As you seek to hold up the regular advancement of a case through communications to your demands that you be allowed to proceed telephonically, we will stand by your prior directive to not communicate outside filings. QB's attorney.
From Bullhorn Betty. Sent, Tuesday, August 15th, 2023, 10:49 a.m. To QB's attorney. Dear Mr. QB's attorney. To reiterate, if your office wishes to stipulate on those 2 items, I will be open to such discussions. Respectfully, BHB.
On Tuesday, August 15th, 2023 at 10:15 a.m. QB's attorney, MX, BHB. Received. Your bar on communication complicates how to proceed, but we will proceed as best we can without further communications. QB's attorney.
From Bullhorn Betty. Sent, Tuesday, August 15th, 2023, 3:09 a.m. To QB's attorney. Dear Mr. QB's attorney. Please find attached the following documents for the above referenced matter. 1. Motion to dismiss counterclaims. 2. Motion to strike bill of particulars. 3. Objection to discovery requests. 4. Motion for protective order. 5. Notice of filing affidavit in support of motion for protective order. 6. Request for telephonic hearing. 7. Plaintiff's first request for production of documents. 8. Notice of filing certificate of service for plaintiff's first request for production of documents. Please let me know if you have any questions. If your office would like to stipulate to dismiss this action against Ms. Heels as co-defendant and the notice for telephonic hearings, please let me know. I apologize, but I am new to the Odyssey system and didn't realize until this morning that the motion to voluntarily dismiss Heels in the air was in their system, but I inadvertently didn't submit and it has been in draft status this entire time. It was successfully uploaded this morning. Respectfully, BHB. From Bullhorn Betty. Sent, Wednesday, July 24, 2024 3:06 p.m. To QB's attorney. Subject, BHB v. QB 2023 LA 16, Notice of Hearing August 16, 2024 10 a.m. Please note that for your record as well. On Wednesday, July 24, 2024, 4:05 p.m. Bullhorn Betty wrote. You and your client like the intimidation route, huh?
On Wednesday, July 24th, 2024, 3:43 p.m. QB's attorney wrote, MX, BHB, your position is noted. We will proceed accordingly. Regards, QB's attorney.
From Bullhorn Betty. Sent, Wednesday, July 24, 2024 1:20 p.m. To QB's attorney. Subject, BHB v. QB 2023 LA 16, Notice of Hearing August 16, 2024 10 a.m. It was an order by the court for my motion. And the prior judge agreed with me that I do not have to attend, except if evidentiary matters arise and trial, and we all agreed. If you want to change the prior order, then you need to do that by motion, not by arguing with me through email. On Wednesday, July 24, 2024 at 2:18 p.m. Bullhorn Betty wrote. Remember, I brought this before the court by motion, you can't change that. On Wednesday, July 24, 2024 at 2:18 p.m. Bullhorn Betty wrote. Now, if you'd like to bring a motion to have it changed, please send it to me at your earliest convenience so I can respond. On Wednesday, July 24, 2024 at 2:17 p.m. Bullhorn Betty wrote. You do not have the authority to change whatever already has been addressed by this court. On Wednesday, July 24, 2024 at 2:16 p.m. Bullhorn Betty wrote. This has been addressed in this very court and settled. You can't now, just because you want to do things that are inappropriate, now force me to come into court because you don't like me. That's an inexcusable argument. You've already raised this concern previously and it was already addressed previously. You are in the wrong here. You need to get your emotions in order and then check.
On Wednesday, July 24th, 2024 at 2:12 p.m. QB's attorney wrote, your position is noted. However, the factual circumstances have changed since then, mainly your behavior and threats towards me. We will be requesting all contested hearings be held in person going forward and, at a minimum, that you comport with the local rules concerning remote hearings. You are not excused from local rules.
From Bullhorn Betty. Sent, Wednesday, July 24, 2024 12:48 p.m. To QB's attorney. Subject, BHB v. QB 2023 LA 16, Notice of Hearing August 16, 2024 10 a.m. This has been settled in the court previously. If there's no evidence being produced by me, I do not need to show up in person. There are not evidentiary hearings, they're oral arguments, and they have been addressed at the very beginning of this court proceeding almost a year ago and well established at this moment. On Wednesday, July 24, 2024 at 1:46 p.m. Bullhorn Betty wrote. For what purpose? They're oral arguments.
On Wednesday, July 24th, 2024 at 1:33 p.m. QB's attorney wrote, MX, BHB, you are not following proper protocol for remote hearings. We object to this hearing being held remotely and will advise the court of the same. You should be prepared to appear in person. QB's attorney.
From Bullhorn Betty. Sent, Wednesday, July 24, 2024 11:33 a.m. To QB's attorney. Subject, BHB v. QB 2023 LA 16, Notice of Hearing August 16, 2024 10 a.m. Dear Mr. QB's attorney. Please find the above notice attached here too. Kind regards. BHB. From Bullhorn Betty. Sent, Thursday, June 27, 2024 2:32 p.m. To QB's attorney. Subject, cease and desist. I will start making sure that you're well abreast of everything that she is doing. I'll be sure to email you all of it so you can be a part of her crimes.
On Thursday, June 27, 2024 at 11:32 a.m. QB's attorney wrote, MX, BHB, my representation of my client is limited to defending your frivolous suit against her and asserting her counterclaims. I am not her babysitter. Unless it has to directly concern the legal proceedings, I am not handling the same. Moreover, I do not work for you. I will be advising the court of your threats against me. seeming to assert I am an accomplice to whatever you claim you will take major actions on. QB's attorney.
From Bullhorn Betty. Sent Thursday, June 27, 2024, 1:24 and 23 seconds a.m. To QB's attorney. Subject, cease and desist. MO Mr. QB's attorney. It has come to my attention that your client is once again stealing my content and making daily videos about me again. She has reached out to yet another family and told them to call the cops on me, which they did, and we have it on videotaped. I have the people stalking me on my job and your client going to her platform for the law enforcement, which I have had it. Your client is a threat to me. She's a threat to people around me, and if this does not stop, I am going to go after sanctions. She is threatening my life. She keeps putting me in danger. Her and her friends keep coordinating against me on every single case I go to, and I am demanding it to be stopped, or I am going to fly in there and I am going to call every single emergency hearing I can possibly call, and I'm going to file every possible report with the police department. I have absolutely had it. She has put my life in danger her last time. If this does not stop, I am going to take major action. Immediately cease, and this is the last letter I'm going to send you to cease and stop assisting your client. I will start serving you as well because you are assisting her at this point. Sincerely. BHB. From Bullhorn Betty. Sent Wednesday, March 13, 2024, 10:37 a.m. To QB's attorney. Subject, service of filing. I didn't ask for legal advice. I asked for who you scheduled this through. I was asking if you made a mistake. I didn't ask for an insult. Nobody in their right mind would have read that letter or email as me asking you for legal advice. I guess you forgot the multiple times I have called Carrie and left her a message that went without a callback, which I find a little odd that you could just call her and get right to her. But I digress. Keep insulting me, and makes you look so much more professional than I already think you are. Please discontinue speaking to me unless it's scheduling related. I don't wish to continue this conversation.
On Wednesday, March 13th, 2024 at 11:23 a.m. QB's attorney wrote, MX, BHB. I scheduled it through the same means you could have, but did not. I called Carrie, got her on my first try, gave her a case number, told her we needed a few hours and it would be in person and evidentiary, got dates, gave you dates to select from, and called Carrie to advise which was selected. I then prepared a notice of hearing and submitted it. I did not insult you. I simply advised you that I cannot ethically provide you with legal advice. Again, I stress that you appear to be looking for reasons to be affronted. Regards, QB's attorney.
From Bullhorn Betty. Sent Wednesday, March 13, 2024, 9:41 a.m. To QB's attorney. Subject, service of filing. Mr. QB's attorney. I am asking because I didn't schedule it. You did. That is why I am asking. I didn't know I needed to be a scholar to ask you who you scheduled this through. But any chance you get to be insulting, you definitely take it, don't you? At this point, I will only be available for scheduling matters. Yes, by all means, tell the judge, include this in another pleading and share it to YouTube. God bless.
On Wednesday, March 13th, 2024 at 9:30 a.m. QB's attorney wrote, MX, BHB. I cannot provide you with legal advice, nor can I educate you on practice in Illinois or the Ninth Judicial Circuit. Regards, QB's attorney.
From Bullhorn Betty. Sent Tuesday, March 12, 2024, 6:06 p.m. To QB's attorney. Subject, service of filing. Dear Mr. QB's attorney. There is a different Judge, James G. Baber, on the notice of hearing rather than Judge William Rasmussen. Why is there a different judge listed? I want to confirm that the hearing is before the correct judge presiding over the matter. Please advise. Kind regards. BHB. On Tuesday, March 12, 2024 at 6:22 p.m. Bullhorn Betty wrote, That is correct as indicated. I thought my hearing was tomorrow. I did not realize it was today. It was an oversight. I have many obligations into my county as well as to my channel, sir. I'm sorry you do not understand that my schedule got screwed up. Clearly, I was going to be at my hearing, not a county meeting, and I'm not going to sit here and explain my oversight to you again and again. I would choose my court hearing any day over a county hearing. Let's be clear on that again. I put my court hearing on the wrong day.
On Tuesday, March 12th, 2024 at 6:05 p.m. QB's attorney wrote, MX, BHB. I am concerned to learn that you elected to speak at a hearing rather than attend your court date today, as shown by the Manatee Board of County Commissioners' regular meeting recorded video. You stated you were going to be there rain or shine. This decision to shrug off the obligations of a suit you brought, with plain indications you knew of the hearing and even told me you would be there, is troublesome and will be brought to the court's attention. Regards, QB's attorney. From QB's attorney. Sent Tuesday, March 12th, 2024, 1:07 p.m. to Bullhorn Betty. Subject, Service of Filing. MX, BHB. Were that the case, I am puzzled why you would have sent this email late last night, specifically referencing today's date and hearing. In any event, as I explained to the court and you, the only item remaining is for you to notice up the motions you want heard that were not already noticed up. The setting is already made, they just need noticed up. Screenshot provided. Further, in this very thread, you stated.
From Bullhorn Betty. Sent, Monday, March 11th, 2024 8:03 and 49 seconds p.m. To QB's attorney. Subject, Service of Filing. I will be attending the hearing on March 12th to make sure this talent made other arrangements, but I will be there to speak to the judge.
As for explaining your need to secure counsel, I believe it is appropriate as we are seeking fees for your violations of Supreme Court Rule 137, and you are making statements about difficulties you have as a pro se litigant. Our position remains the same. If you cannot comply with the applicable rules, you should retain someone that can. And by asking you to secure counsel, we are ensuring we do not waive that position. You can choose to be offended by the suggestion that you may need counsel, or you can ignore it. It is in no way offensive. But I must do my best for my client to advance her position for a fee award. Sincerely, QB's attorney.
From Bullhorn Betty. Sent, Tuesday, March 12th, 2024 12:47 p.m. To QB's attorney. Subject, Service of Filing. I thought it was scheduled for tomorrow. Either way, once again please refrain from speaking down to me. I've repeatedly asked you to spot advising me to seek counsel. Please show me that respect and refrain from that moving forward despite your feelings to continue to advise the same thing over and over again. Why do you care so much? Take care and God bless. I will speak to the judge tomorrow.
On Tuesday, March 12th, 2024 at 11:24 a.m. QB's attorney wrote, MX, BHB. I am afraid, as stated before, you are simply looking for reasons to be outraged. I am not insulting you. As always, counsel properly licensed and familiar with Illinois practice would understand these matters. Had you retained counsel, this case would undoubtedly be resolved or nearly resolved by this point. That said, you did not appear for the case management conference today. Despite my suggestion attendance was expected. The court seems surprised you were not there, in my opinion. In any event, in full disclosure, I advised the court that we had a setting for April 17, 2024, for an in-person hearing, including an evidentiary matter. I mentioned that it seemed the only thing left for you to do between now and then was for you to notice up whatever motion you want heard that I have not already noticed up. The matter was set for an additional CMC in May. Regards, QB's attorney.
From Bullhorn Betty. Sent, Tuesday, March 12th, 2024 7:20 a.m. To QB's attorney. Subject, Service of Filing. Yes, and insulting me yet again is really going to help you in the future. You're creating a combative work environment with me intentionally and I'm getting sick and tired of it.
On Tuesday, March 12th, 2024 at 8:18 a.m. QB's attorney wrote, MX, BHB. Attendance at the CMC is not excused, to my knowledge, simply because we have another hearing scheduled. The court is aware of the setting, you need only notice it up. I did not deceive you. You just do not know how civil practice in Illinois works. Please secure counsel, he or she would understand. Regards, QB's attorney.
From Bullhorn Betty. Sent, Monday, March 11th, 2024 8:03 and 49 seconds p.m. To QB's attorney. Subject, Service of Filing. I will be attending the hearing on March 12th to make sure this calendaring and scheduling issue is done appropriately. If you'd like to attend you may. I'm not sure if you're required to since we went ahead and made other arrangements, but I will be there to speak to the judge and I'm letting you know that now. On Monday, March 11th, 2024 at 9:02 p.m. Bullhorn Betty wrote. So, although you reached out to me, knowing I had scheduling issues and I asked you to go ahead and provide me dates and times, you intentionally deceived me and didn't schedule the other motions that I needed scheduled. Knowing this while I was under the assumption we were taking care of all of this according to your email, a 3-hour hearing. I will notice mine for the 3-hour and I want to make sure that I'm not going to have any more flack from you. It'll all be heard this day. If you have a problem with that you better let me know, otherwise I'm bringing this to the judge because that's what was implied in your prior emails. On Monday, March 11th, 2024 at 9 p.m. Bullhorn Betty wrote. I just assumed since we were scheduling everything that you would just do the courtesy, but of course, why would I expect professional courtesy from you?
On Monday, March 11th, 2024 at 2:20 p.m. QB's attorney wrote, MX, BHB. It is not my job to notice up your motions. If you want that heard, you should notice it up. QB's attorney.
From Bullhorn Betty. Sent, Monday, March 11th, 2024 1:04 p.m. To QB's attorney. Subject, Service of Filing. I don't see any counterclaims motions attached. Please advise. Thanks.
On Monday, March 11th, 2024 at 12:23 p.m. QB's attorney wrote, "Greetings. I have attached a copy of a filing. It was filed with the clerk of the court using the Odyssey e-filing system today. If you have any issues opening the file, please let me know. QB's attorney."
Okay, guys, that about covers it. What are your thoughts in the comment section below? If you're watching the replay, those who came to the premiere, I truly appreciate each and every one of you for being here. Have an amazing day, night, evening, wherever you're at. Hey, Betty, you need a lollipop? I've got extras. In my opinion, Queen Bee's lawyer has been completely professional through this entire procedure. Betty has been, in my opinion, a pain in the royal ass. I feel bad for him, but his spice, I'm here for it. Thank you, guys. Have a great night, and I'll see you next time. Bye.